Judgment in the appeal of Rubin and another against Eurofinance and UKSC Reinsurance Corporation against AE Grant and others.
Lord Sumption will give the judgment.
The question in these appeals was, in what circumstances will the English courts enforce or recognise as binding the judgments and orders of foreign courts in insolvency proceedings? The ordinary rule of English law concerning the enforcement or recognition of foreign judgments and orders has been settled for many years. Broadly speaking, and at the expense of a good deal of oversimplification, it depends on whether the order of the foreign court determines the status or disposes of title to a thing, an order in rem, or whether it determines the rights or obligations of a person, an order in personam. The English courts will only give effect to foreign judgments or orders if, according to English law principles, the foreign court is regarded as having jurisdiction. This means that the property, in the case of judgments or orders in rem, or the person, in the case of judgments or orders in personam, must be situated within the territorial jurisdiction of the foreign court, or else, in either class of case, the person against whom it is sought to enforce the judgment or order must have voluntarily submitted to the jurisdiction of the foreign court, for example, by actively participating in the foreign proceedings. It's irrelevant that the foreign court may have had jurisdiction according to its own rules. It must have jurisdiction according to the English law rules for recognizing foreign judgments, which are commonly more restrictive. Insolvency proceedings are in some respects special. In the first place, many judgments or orders in insolvency proceedings cannot realistically be classified as being either in rem or in personam. They are simply a mode of collective enforcement of debts. Secondly, the English courts have long recognized that international cooperation is desirable in the interests of a fair and rational administration of an insolvent estate with assets located in several jurisdictions, and that if it can properly be done, a single jurisdiction should govern the entire administration of an international insolvent estate. The essential question on these appeals was whether these considerations justify a broader approach to the enforcement or recognition of orders and judgments in foreign insolvency proceedings in cases where the order or judgment in question undoubtedly is a judgment in rem or in personam. To some extent, this has already been achieved by international agreements incorporated into United Kingdom legislation or by United Kingdom statutes providing for our courts to assist foreign insolvency courts. Both approaches have therefore been adopted to some extent in the United Kingdom, but only within defined limits, which are not broad enough to accommodate these particular cases. Both of these appeals arise out of decisions of foreign insolvency courts setting aside transactions under their own legislation and making consequential orders against the defendants in the English proceedings. Such orders are orders in rem, albeit that they have as their object the fair distribution of an insolvent estate between creditors generally. The first appeal, Rubin, relates to a judgment by the United States Federal Bankruptcy Court for the Southern District of New York for about $10 million arising from the setting aside of what were said to have been fraudulent conveyances and transfers. Proceedings to enforce the orders were subsequently taken at common law in England. The second appeal, NewCap, relates to a judgment of the New South Wales Supreme Court for about $8 million, arising from transactions characterized as unfair preferences under Australian law. Proceedings to enforce it were later taken in England under the Foreign Judgments Reciprocal Enforcement Act 1933, which applies as between the United Kingdom and Australia. In both of these appeals, the judgments were entered in the absence of the defendants, who were not present in the foreign jurisdiction. By a majority of 4-1, this court has decided that there should not be special rules for judgments or orders in personam made in such proceedings to be recognized and enforced in England. The reasons are given in the judgment of Lord Collins. It therefore follows that the appeal in Rubin must be allowed, since in Rubin the defendants did not in any way participate in the foreign proceedings. The real issue is one of policy. A creditor with a judgment against it for the repayment of a preferential payment, for example, should not be in a worse position than a debtor with a judgment against it for a debt due to the company in liquidation. A different rule for such proceedings would require this court to establish new rules for deciding in what circumstances a foreign insolvency court should be regarded as having personal jurisdiction over a judgment debtor. What connection between the judgment debtor and the foreign jurisdiction is sufficient for that purpose? Such a change would not be an incremental development of existing principles of law. It would be a radical departure from substantially settled law, and if such a change is to be made, it is more suitable that it should be made by the legislature after such arrangements had been considered for reciprocal arrangements with other states as might be thought appropriate. The restricted scope of the existing rules reflect the fact that there is no expectation of reciprocity on the part of foreign countries. It could also be detrimental to the United Kingdom business without any corresponding benefits. Nor would any serious injustice result, in the opinion of the majority of this court, from not departing from the traditional rule, because there are other avenues open. Rubin, for example, could have been founded on proceedings by trustees in England for the benefit of creditors under an express trust, and preference claims by the liquidator of an Australian company could have been the subject of a request by the Australian court under English insolvency legislation. In relation to NewCap, the court unanimously agrees that the syndicate, although not present within the territorial jurisdiction of the Australian court, had submitted to its jurisdiction by putting in a claim for its debt in the Australian insolvency. The facts which have led the court to allow the appeal in Rubin were therefore different in NewCap, and the same questions did not arise. The result is that the Rubin appeal will be allowed and the NewCap appeal will be dismissed.